Good afternoon, everybody. Welcome to the International Human Rights presentation on combating sexual violence in Tanzania, perspectives from a human rights practicum. My name is Yamari Cham, and as John Lamont, Christina Buccina, Shannon Sherrill, Dennis Maxwell, Lena Goldie Desmond, and our lovely professor, Professor Bond. The course teaches students how to apply international and regional human rights treatises to real-world human rights problems. Through experiential learning, students engage in extensive legal and policy analysis of real human rights problems, primarily in Africa, and students develop a better understanding of challenges, social justice potential of the human rights framework. In partnership and collaboration with non-governmental organizations that are based in the US or Africa, students promote human rights and seek redress for human rights violations. We engage projects that may involve human rights fact-finding, legislative advocacy, test case litigation, capacity building, and other forms of human rights advocacy. This year, we're doing fact-finding work in investigating the enforcement of the Sexual Offenses Act of the Republic of Tanzania, which was enacted in 1998. Tanzania is located in the eastern part of Africa, and it is constituted by mainland and the islands of Zanzibar and Pemba. Tanzania has 26 regions with more than 40 million people and 2 official languages, Kiswahili, which is the de facto official language, and English as a result of its former status as a British colony. Since 1996, the capital was moved to Dodoma, which is somewhere not quite in the middle, but prior to that, it was in Dar es Salaam, which is located in the eastern part of the country, and we actually stayed in Dar es Salaam when we visited during fall break. We were invited by the Women's Legal Aid Center, WULAC, a nonprofit organization in Dar es Salaam that was formed in 1994. WULAC invited us to collaborate with them and investigate the implementation of the Act. With a growing emphasis on a practice-based simulation and real client experiences, WULAC's invitation was very, very timely for WNO. Sexual violence occurs throughout the country, and Tanzania is no exception. And like most countries, there's very little data and agreement about the prevalence. But we're all in agreement that sexual violence has lasting impact on the physical, mental, and social well-beings of the victims. Here at WNO and globally, there's a growing focus and interest on these human rights issues. Our level of commitment has never been higher. Like courses like the International Human Rights Practicum and the Transnational Law Institute programs, we sort of have this watch eye for any types of violations, and we collaborate with partner organizations to hold countries accountable. Although governments implement legislations like the Sexual Offenses Act, that's not enough. Only vigilant attention and holding them accountable will ensure that the inclusion of human rights in stated policies will be more than simply a symbolic gesture. So, in October, we traveled for 10 days, did some field work for our investigation project, and while we were there, we conducted about 60 interviews, and our interviews ranged from stakeholders in the judiciary, law enforcement, police officers, healthcare workers, and non-governmental organization workers that provide legal services and counseling to victims of sexual violence. While SOSPA combats various issues, at the request of WULAC, we focused on rape, sexual violence, female genital mutilation, human trafficking, and other issues related to domestic violence. Now that we're back in the US, we're in the process of compiling our findings into a human rights report that our partner organization, WULAC, will use to convince the Tanzanian government to further adjust the laws if necessary, provide recommendations on how to proceed, and on not just the implementation, but the legal procedure on dealing with reportings. That'll improve the enforcement and fulfill Tanzania's obligations under international human rights law. Now I'll pass it on to Shannon Searle, who would talk about the relevant provisions of the Sexual Offenses Act. And guys, feel free to grab food and beverages anytime. So, thank you.
We'll be swapping out a lot, so you can clap if you want, but
we can freely wander about.
you can wander about. We'll be wandering about back and forth, and also if you can applause if you want for each person. It makes us feel better, but you can hold it to the end. Thanks, Yamarie, for the background and context. I'm going to talk about the law that was the specific focus of our trip, which is the Sexual Offenses Special Provision Act, or otherwise known as SOSPA. As you can see from the quote, there was some internal pressure to do something about the growing problem of sexual violence, or there was a perception that the problem was growing, and we think that perception was accurate. And in response to that, they passed SOSPA. There was also external pressure based on the international agreements and conventions that Tanzania is subject to do something about the problem of sexual violence. So I'm going to briefly touch on some of the major provisions of SOSPA. One of the important things that SOSPA did was redefine rape. Prior to SOSPA, under the Tanzania's penal code, rape was defined merely as unlawful carnal knowledge of a woman or a girl. I think that's verbatim. And SOSPA redefined it so that rape includes intercourse between a male and a female where the woman does not consent and the couple are not married, or if they're separated. If they're married and separated. It also, within the definition, includes intercourse when a man uses threats or force to obtain consent, and there's also a provision for statutory rape for intercourse with a girl who's under 18, although that provision is qualified for age 15 if the girl is married to the man. So you can see it added some precision to the definition of rape that didn't exist under the penal code before. And it also significantly increased penalties for rape and attempted rape. Before SOSPA was passed, most convicted rapists received only 5 years. And there are a couple of isolated instances in which the trial court only penalized the rapist with a small fine. Under the penal code, the judge actually has no discretion at all in sentencing. A rapist, when convicted, will receive 30 years in prison. If the victim is a young child, the rapist will receive life in prison. The judge doesn't have discretion to alter those sentences at all. Also, attempted rape under SOSPA carries a sentence of 30 years in prison. SOSPA also introduced new sex crimes that didn't exist before. For instance, gang rape, which is punishable by life in prison. Gross indecency, sexual exploitation of children, grave sexual abuse. These crimes also have strict sentencing guidelines, much like the new sentencing guidelines for rape and attempted rape. SOSPA changed the evidence law to make it explicitly clear that corroborating evidence is not necessary to achieve a conviction in a rape case. Prior to SOSPA, it was treated essentially as a rule of law that the victim's testimony itself was presumptively insufficient to convict. Also, SOSPA makes express a requirement of proof of penetration in rape cases. And SOSPA criminalizes FGM, female genital mutilation, as Yamarie mentioned, sometimes called female circumcision. And Dennis will talk more about that in a little bit. But prior to SOSPA, FGM was not illegal in Tanzania. And SOSPA included it under a category of child abuse offenses, so that it's now criminal to perform the procedure on a child under 18. And finally, and these are just sort of touching on the major changes that SOSPA brought, human trafficking was not against the law expressly in Tanzania before SOSPA. And SOSPA provides for 10 years in prison for a person convicted of trafficking for commercial sex to and from Tanzania. And with that sort of context from Yamari and sort of the background of the law that we went to look at specifically, I'm going to turn it over to Lena, and she's going to talk about some of the systemic and cultural obstacles to implementing the law.
Shannon, can I ask a quick question?
Sure.
How long did these major changes take, and what was, I mean, obviously we were talking, your research was about the effect and how it's being implemented, but these are pretty serious transitions. I mean, how much pressure did it require?
Well, I guess there's different ways to look at that question. One is, how long did it take to implement these pretty radical changes? And I guess we're going to talk about that, or some other folks are going to talk about that, so I don't want to steal their thunder. But our findings, our conclusion might be that some of them haven't yet been implemented fully at all. And so it is a fairly long metamorphosis. In terms of lobbying for the change, it was a number of years. In fact, there was a government commission that was established in 1991, or tasked in 1991, to look at the problem of gender-based violence and sex crimes. And it wasn't until 1998 when, in fact, that commission was releasing its report over those intervening 7 years that it spent working on it, that the law was passed. So it was a problem that was a long time in coming. So, and Lena.
Would you rather we hold our questions until you're all done, and you would rather that?
That would be best.
Okay.
But if it's particularly a burning question, you can.
Well, I always have burning questions.
So now we're going to talk a little bit about implementing SOSPA. And despite the relatively progressive nature of SOSPA, there are several systemic problems, not only in particular to Tanzania, but we're looking at Tanzania now, that prevent its successful implementation. And those are the cultural attitudes towards women, the role of law that in Tanzania, the lack of resources, and corruption. So these are some quotes that were taken from women in the law enforcement and judicial sectors, and they reflect prevailing attitudes that still exist in all sectors of society, including government. Women's role in Tanzania is still subordinated, despite some legal and political advances. And there are also different concepts of consent versus rape, and still a pervasive idea, again, not just in Tanzania, that no really means yes. While we heard about rape of young girls in our interviews, we rarely heard reports of rape of adult women. And this doesn't mean that it doesn't happen, but it can be partly attributed to the fact that the cultural view that somehow these rapes are inevitable. Additionally, there was essentially no reporting of marital rape, because consenting to marriage is seen as consenting to sex anytime, any place within that marriage. There's also a great stigma faced by women if they report rape, especially adult women. This is partly because the family is also seen as shamed, and she is seen as less marriageable and tainted. So the role of law in Tanzania is also sometimes problematic. This is a photo of the cases of the Court of Appeal, so there's a filing issue as well. And that's their Supreme Court, so this isn't just a local court. Tanzania has an English common law system, but it also incorporates customary law, that's law from tribes or communities within Tanzania, and both can be discriminatory towards women. For instance, while boys must be 18 to get married, girls can be married at 15 with the consent of their parents and the courts. Customary inheritance laws can also ban women from inheriting property. Another problem is that many laws are published only in English, and therefore must be translated into Swahili. And this is problematic because most people in rural areas, including government officials, speak only Swahili, or even only their tribal language. So this means that some people won't know of the law specifics. And for example, the movement of girls from upcountry to urban areas to work by agents to work as housemaids or prostitutes can fall into the definition of trafficking, but most people see this only as internal migration, and this prevents the opportunities for legal redress. Another problem is lack of resources. Tanzania is not a wealthy country. In fact, it's one of the poorest countries in the world. So governmental resources available to investigate gender-based violence are relatively few, and they're also investigating such crimes are pretty low on the priority list. If they have to choose to look at murder or robbery, they will choose to use their resources for that. And the legal process for a rape case, because of the lack of resources, can take a long time, can take 4 years. So there's increased pressure to negotiate with the perpetrator for out-of-court resolution. And this compensation by the perpetrator can be as little as 50 to 100,000 Tanzanian shillings, which is about $40 to $80. This is still hugely valuable for families, however. And this is problematic because the money will usually go only to the family and not to the victim. And the final problem is corruption. Corruption is pretty prevalent, although there is movement to address it at the higher levels of government. It's driven by the aforementioned lack of resources. As you can see from this photo, this is the the government-sponsored housing that police get. And to supplement their income, they can accept bribes by the perpetrator or the victim to make the case simply disappear. Corruption happens in all the players of this system, including judges, court clerks, and doctors. So these are some broad systemic problems, and John will now talk about the specific problems in implementing SOSPA when it comes to rape. Go for it.
Thanks. All right, so as you heard from Shannon, rape is one of the offenses that was specifically targeted by SOSPA, and you heard from Lena what some of the overarching challenges are. So I'm going to talk about some of the obstacles that arise at each stage of a rape case so you can get some sense of the difficulties in implementing SOSPA. So the first major hurdle is getting victims to report at all. At an August 2007 forum that was organized by the Tanzania Media Women's Association, it was estimated that 80% of rape victims never report their cases. So why do so few report? Well, the biggest obstacle Lena sort of talked about is shame. In Tanzania, there's more shame associated with being identified as a victim of rape than there is being identified as a rapist by the community. And this makes victims and their family unwilling to come forward. Also, many times the rape can occur inside a family. An uncle or a grandfather may be the perpetrator, and this further inhibits reporting. Additionally, with adult women, it's particularly an issue. In asking police and doctors if they ever saw adult victims of rape, they said that it was very rare. And one activist who actually works with these issues said herself that she would be hesitant to report a rape. So the shame associated with being a victim and the circumstance in which the victim and the perpetrator know each other drives the phenomena of private settlements. So instead of reporting to the police, many victims and their families choose to reach settlement agreements with the perpetrator, so the victim's family may receive compensation, or the victim and the perpetrator may be joined in marriage. So a further complicating factor is just the sheer distance that's involved in reporting for some of these victims. Only 25% of Tanzanians live in urban areas, and this means that many victims don't have ready access to a police station. So in order to report, oftentimes they have to travel 6 or 12 hours just to report the crime to the police. This map shows the population density of Tanzania, and it gives you some sense of the problem. You can see that Dar es Salaam is relatively densely populated with nearly 1,800 people per square kilometer, but you can also see that this is the exception rather than the rule. So even if a victim takes the first step and reports the crime, there are still a lot of obstacles to overcome, and one of these obstacles is police attitudes. Often the police see rape as a family matter, and they aren't interested in getting involved. And this can be related to the frequency with which victims decide not to go forward with the cases and to settle instead, but also the frequency with which family, neighbors, and friends are the suspects in these cases. But whatever the reason, it's an inappropriate response, and it presents an obstacle to victims who do want their cases heard by the courts. So police actually have a lot of discretion in deciding whether or not to take a case forward. An officer on the beat can decide that a case isn't legitimate. And this may happen if, for whatever reason, he thinks that the rape report is a false one. And there's no real oversight of this discretion and no records of how many cases disappear in this way. If the local police decide to move forward with the case, there's another stage of review at the regional police office. They also decide whether or not there's enough evidence to go forward and whether the case is legitimate. And according to one regional investigation officer we spoke with, about 50% of cases do not go forward based on this exercise of discretion. So evidence collection is a problem at this stage of the case, and one of the reasons is that victims don't really know the procedure for reporting. They don't know that they shouldn't wash themselves or their clothes before reporting. And there's also often a delay in reporting, and this can be related to the distance that the victims have to travel, but more often it has to do with the victims and their families taking time to decide how they want to proceed. They decide whether or not they want to report the case or try to reach a private settlement, and this takes time. So a lack of resources also inhibits evidence collection and investigation. One interviewee told us that if you call the police to report a robbery, the police may not always have a vehicle with which to respond to the scene of the crime. So the police have to prioritize their resources, and unfortunately, rape isn't often a high priority for them. So this is Police Form 3, commonly referred to as the PF3, and it's the central piece of evidence in rape cases. It's highly valued because it's filled out by doctors, and doctors are thought to be objective and neutral parties. So victims are first supposed to report to the police, and they fill out an initial report, and then they collect the PF3 from the police, and then they report to the hospital. The doctor fills out this form after he evaluates the victim, and really this form comes down to whether or not the doctor sees evidence of penetration or not. So there's some confusion about how the PF3 actually works. When we talk to NGOs, they would tell us that there were victims who would go to the hospital without a PF3, and they would be sent away without treatment in order to go back and get the PF3 and then come back to the hospital. But when we talked to doctors, they said that they never turned away victims without treatment, so there's some confusion as to what's going on. And because the PF3 is such a critical piece of evidence in these cases, people often try to influence the doctors. So one officer, for instance, told us that in some cases, the family of the perpetrator bribes the doctor to fill out the PF3 form to say that there is evidence of penetration. And then on the other hand, we heard from some hospital administrators who say that sometimes the families of the victims pressure the doctors to fill out the PF3 form to say that there is evidence of penetration. And again, doctors face some of the same challenges in examining these victims that the police face, namely that the victims don't promptly report and they often wash themselves before they do report. And doctors also don't have all the resources they need to collect evidence. For instance, DNA testing isn't really available in Tanzania. Collecting evidence is especially challenging for women who are not virgins, since trauma to the hymen is the main indicator used to determine whether or not there is penetration. And finally, cost can be a barrier to some victims. So it costs 500 shillings to open a file, it costs 3,000 shillings to admit a patient to the hospital if that's necessary, and 5,000 shillings to generate the rape report. So certain types of patients qualify for exemptions from these fees, but their availability can depend upon whether or not the hospital has the resources to grant them. And resources obviously are a big problem. They don't always have those resources. So finally, the last stop for these victims is the courts. And if a victim has made it this far, then they've made it farther than most. They've overcome a lot of obstacles, but even at this stage, there are more obstacles that they have to overcome. So you may remember that about 50% of cases stop because of an exercise of police discretion. And of these 50% that go forward, about 10 to 20% are dismissed by judges in the initial stages of the case for failure to establish a prima facie case. So ultimately of cases that are prosecuted, really only about 25% of them are successful and result in convictions. So why is it so difficult? Well, it's hard for the victim, and the victim is really the government's key witness, and you can't go forward without them. It's a long process, as Lena said. One former prosecutor told us that in a best case scenario, it may take 6 months to get through these cases, but it's far more common for it to take 2 or 3 years to conclude one of these cases. And this creates a difficulty with the witnesses. So first, it's hard to secure the cooperation of witnesses at all, let alone to do so for an extended period of time. And it creates special challenges with medical evidence, which, as you heard, is key. So in order to get that PF3 form admitted, you have to get the doctor who filled the form out to testify. And when you're talking about a wait of 2 or 3 years, it might not be possible to locate that doctor. They might have been transferred to another region, or many of them go abroad for study or other reasons. So corruption is another challenge, and it's often related to the delays in the courts. And a survey by one NGO found that 60% of the respondents believe that corruption has rendered the Tanzanian judiciary ineffective. Competence is also a problem with some of these courts, especially at the lower courts and particularly in the upcountry courts. Some interviewees told us that the magistrates aren't always familiar with the laws that they're supposed to be applying. And finally, SOSPA's sentencing provisions can also make it difficult for a case to succeed at trial. And although, as Shannon said, the law was really designed to make it easier to get these convictions, for example, by removing the corroboration requirement, in practice it's really not that easy. And this is because defendants are often looking at 30-year sentences in a country where life expectancy is only 50. And because of this, magistrates are really hesitant to convict a defendant if they're not absolutely sure. So SOSPA's sentencing provisions have kind of cut against its evidentiary revisions. And now I'm going to turn it over to Dennis to talk a bit about FGM and trafficking.
John has taken some time to go through some of the issues dealing with prosecuting rape under SOSPA. I'm going to talk to you a little bit about female genital mutilation and trafficking and some of the issues surrounding those. As you see here in this slide, here are some examples of some of the instruments that are used in the traditional practice of female genital mutilation in Tanzania and other places where it's practiced. Female genital mutilation, sometimes called cutting or female circumcision, it's a deeply ingrained traditional practice, and it's usually associated with coming-of-age rituals. In Tanzania, it's most prevalent in the rural regions, in particular the regions of Arusha and Dodoma. Those regions have high incidence. In fact, in Arusha, almost 81% of women in Arusha have been circumcised, and in Dodoma, it's 68%. It's particularly among certain tribes in Tanzania. Tanzania actually is home to about 120 tribes, only some of which practice this. Particularly the Maasai are known, it's very prevalent, the practice is very prevalent among the Maasai, where nearly every woman is circumcised, as well as the Kuria. There are other tribes that include the Gogo, Nyaturu, as well as the Chaga. But in those tribes, the incidence of it is actually going down, and that's due to intermarriage with tribes where it's not a practice, and also increased education in the areas where they live. Victims face a lot of pressures to undergo circumcision. Particularly, they face pressure from their peers. They face pressure from the community, since it's a community-wide belief. And particularly, they face pressure from their families. Marriage in Tanzania, in the rural areas in particular, there's still often the tradition of bride price being paid, where the groom's family may pay the bride's family for the privilege of marrying their daughters. And circumcision actually may affect the bride price, or the woman, again, may be unmarriageable, in which case the family suffers economically. The perpetuation of the practice in communities, that stems from certain beliefs, particularly that there's some hygienic aspect to the mutilation. Basically, that the clitoris is unclean, and there's also a belief that if a baby during childbirth touches the clitoris, it can kill the baby. Again, there's this issue of marriageability. In particular, men view women who are circumcised as being fully woman, and those who are uncircumcised they see as girls. So it's much less likely for a man is much less likely to want to marry an uncircumcised woman. Ultimately, however, the main reason for this practice is the belief that a woman who is circumcised is less likely to be promiscuous, that female genital mutilation removes a woman's sexual urges, and therefore she's less likely to engage in adultery. Now, the practice raises certain medical concerns. In particular, during the actual practice, it's usually performed by traditional practitioners who have no medical training whatsoever. And complications are likely to arise. There's severe bleeding, infection, and in rural areas, healthcare is often not available at all. So when these complications arise, death can certainly result. Likewise with maternal death. Given the fact that FGM is likely to cause complications during childbirth, and the fact that childbirth takes place at home in most of the rural regions, it's likely to increase maternal death in rural areas. Now, the problems with investigation really, in part, stem from these community beliefs, this community acceptance of the practice. For one thing, police officers may actually come from communities that practice FGM, and therefore are not really all that eager to investigate the practice. But even if that's not the case, the police have to rely on communities in order to find out when the practice is going to take place and how to go about investigating it, whether it's been reported after the fact. And communities that are firm believers in this practice and accept it are not likely to give the police that information. And as Shannon said, SOSPA has made the practice illegal in some cases. And so to avoid that, lots of communities are now practicing FGM on very young girls who are not likely to report it and not likely to try and flee. And they're also practicing it on adult women. And under SOSPA, FGM is not a crime when performed on an adult. When FGM comes to the courts, that's very rare. They very rarely are seen in the courts for a lot of the reasons we just spoke, the problems with the investigation. And even when they do come, witnesses are not likely to want to testify against other members of the community, especially when they themselves might believe in the practice. But there are also unique problems with prosecuting female genital mutilation. For one thing, the perpetrators are almost always the parents of the girl, of the victim. And if they are convicted, they end up going to jail, in which case the child is left with no parents. Now I'd like to shift gears a little bit and talk about some of the problems and some of the issues that arise in prosecuting trafficking. Human trafficking in Tanzania, the vast majority of these cases are where a member of the victim's extended family comes and traffics the victim. And we're not always talking about sex trafficking. Sometimes it's for domestic help and forced labor, essentially. To understand this problem, it's important to understand African views on family and what an extended family actually is. In rural sections of Tanzania, family is not just blood relatives, but that definition may extend to many members of the community in which the victim lives. So some of what happens is members of that community will go and then move to the city, and they'll return to their rural village on a visit. And when someone comes from the city to a rural village, they're usually considered to be rich, whether they're rich or not. So these people who return from the city then convince the families that their victim would be better off with them in the city, and that they would provide education and they'd provide opportunity that wouldn't otherwise be available. And because there's this sense of family, the parents trust the perpetrators to provide the care for their child as if it were their own. Unfortunately, what happens is that when these victims arrive in the city, they're often put to work as domestic help. Sometimes they're forced to be prostitutes, and sometimes they're simply sold into slavery. Because of this idea of family, parents are not likely to report their child missing, even when they haven't heard from them in some time, because they still have this idea of trust of the perpetrator. Most cases aren't discovered until the victim is able to escape because of the lack of reporting. And as a result, very few cases are prosecuted. Now, for both FGM and trafficking, it should be noted that the police at this point are merely responding to reports. They're not taking proactive steps to combat the problem. They haven't been proactive in it. And the problem with that, of course, is first that, especially in the case of FGM, once the case is reported by a victim, the damage is already done. But more importantly, oftentimes they're not going to report because it's their parents who are the perpetrators. Or in the case of trafficking, the victims often can't report and the parents aren't likely to. So this is a problem that has to be dealt with in a number of different ways, in which I'm going to turn it over to Christina to talk about some of the domestic initiative.
Well, in light of the challenges you've just heard about, both the larger systemic problems and the specific challenges to the certain crimes, the government and various NGOs have made efforts through policies, training, educational outreach, to attempt to supplement the law in the battle against sexual violence. This is a picture of a tile outside the WILAC office that was our partner organization in Tanzania, and it's illustrating the idea of domestic violence, and then education produces a happy family. So that's the goal that they're working towards. The Tanzanian government does have ministries in place, some of which have policies that cover these issues of sexual violence. But unfortunately, what we found both there on the ground and in our research afterwards is that the government hasn't really achieved much at all in the implementation of these policies. The budgets for these plans have not been given any funding, and any activities the government has done to implement these policies has all been sponsored by outside donors. Only a small amount of training and awareness raising activities have been put on by the government, And in virtually every one of those programs, the government relied heavily on NGOs to do the actual work. So as I just said, NGOs are really doing the brunt of the work there in Tanzania. Our interviews suggested that NGOs have been doing pretty much all of the work in the fight against sexual violence. They've done a lot of educational outreach. They go out into the communities, including the rural villages. They put awareness campaigns in the media. They've worked really hard advocating for legal reform, both before SOSPA, and now they're lobbying to get SOSPA to include marital rape in the definition of rape. They've also worked really hard to revise laws that are discriminatory against women. And they also provide a lot of really useful legal services. As Lena mentioned, a lot of this stuff is in English. The general population speaks Swahili, so the NGOs there have done a lot of help with document preparation, giving advice about the procedure of the cases, and they've also done a lot to help increase women's legal literacy and inform them of their rights. Training institutional reform, for example, WILAC, who we worked with, they've trained police, they've trained paralegals to help women, they've trained the media on how to report these cases effectively. They've even trained judges and prosecutors on the law and what it says and how they should apply it. This is a picture of some young girls at a shelter in Dar es Salaam that we visited. At this particular NGO, they do a lot of different things, but we mostly talk to them about the work they do to fight trafficking. And I just wanted to include this as an example of what's been a really successful multi-sectoral approach to the problem. This NGO has worked with police to help identify victims of trafficking, local leaders. Once they rescue the children, they put them in school, they get them medical care. You can see a sewing machine in the background. They train them in vocational skills so that they have some means of earning income. And they also go out into communities proactively and identify at-risk children, and those children can also come to these shelters and get vocational skills and training and medical care as a preventative measure. And since 2004, this particular NGO has rescued 250 children from prostitution or domestic slavery. While these efforts by NGOs are phenomenal and we hope that they continue, it's really the Tanzanian government that has the responsibility under international law to combat these human rights issues. So it's not sufficient for the government to rely solely on NGO to pick up the slack.
Tanzania, under international law, has incurred certain obligations, and their obligations really stem from a number of documents, including what you see up here. One of the document you first see listed is the UN Declaration on the Elimination of Violence Against Women. It was a resolution that was adopted by the UN General Assembly in 1993 unanimously. And it's specific regarding gender-based violence, and it's a statement of principles that the international community has set forth that member states of the United Nations should work to combat gender-based violence. And that came on the heels of the UN Convention on the Elimination of All Forms of Discrimination Against Women, otherwise known as CEDAW. That came into force in 1981, and it's an optional convention of the UN, and it's binding. Its terms are binding. Tanzania ratified it in 1985. At first, it was targeted more at economic and political and social rights of women. But in 1992, the UN committee, which oversees the implementation of the convention, issued its General Recommendation 19, which interpreted the meaning of discrimination to include sexual violence towards women. In addition to the UN documents you see here, Tanzania is also party to a number of regional protocols, including the protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, also known as the Maputo Protocol. This is a protocol to the African Charter, which itself has broad statements on human rights. but the Maputo Protocol was added to signal the Africa's commitment to women's rights. And it has specific language requiring states parties to make efforts to combat gender-based violence. Tanzania ratified that protocol in 2007. In addition, there's the Southern African Development Community's Protocol on Gender and Development. And like the Maputo Protocol, it also requires states parties to make efforts to combat gender-based violence. All these conventions basically stand for the obligation of states to uphold basic human rights and fundamental freedoms, especially in regards to women. And these freedoms, the right to life, liberty, and the security of person, the right to equal protection under the law, the right to the highest attainable standard of health, and the right not to be subject to torture or any other cruel or degrading treatment. And the international law actually also requires Tanzania not just to combat conduct by the government, but also to combat such conduct that violates these rights by private actors. And one of the ways in which Tanzania is obligated to work towards this is to change cultural attitudes, either through legislation or through other means, through education and awareness. This article from CEDAW is basically is a statement about the obligation of states to change cultural attitudes. The Maputo Protocol has similar language. Additionally, even more strenuously, the SADC Protocol requires states parties to take measures to discourage traditional norms, including cultural practices, which legitimize and exacerbate the persistence and tolerance of gender-based violence with a view to eliminate them. In order to judge how Tanzania is doing, I'm going to turn it over to Lena.
So it's all well and good that we have these international or that Tanzania has international obligations, but the question is, how do you measure whether state is achieving or failing? And the standard that the international community, especially under CEDAW and DIVA, which were the conventions on the elimination of discrimination against women, what they came up with is the due diligence standard. This applies to both state and private actors, and it is a way to measure whether state is meeting its obligations. This standard judges state action by how much the state has done in terms of prevention, investigation, and punishment, or PIP, as I like to call it. And other conventions that the state has signed may go into more detail about what those duties entail. For example, the Maputo Protocol specifically says, states parties shall take appropriate action and effective measures to punish the perpetrators of violence against women. And Tanzania is making strides to achieve this due diligence standard, but unfortunately it's not doing enough. In terms of prevention, cultural attitudes are still deterring reporting. Gender-based violence is still too pervasive in all sectors of society. There needs to be more investigation of gender-based violence by the police, and there also needs to be a better system of keeping the statistics, otherwise you won't know what the scope of the problem is and how to address it. And in terms of punishment, sentences may deter reporting, and they raise the evidentiary burden in a practical sense. The length of the court process and the lack of compensation through the court system drives victims to out-of-court resolution. And unfortunately, if Tanzania doesn't do more, it will fail in its international obligations. So in order to address how they may not fail, we're going to go to the recommendations section, which we're doing.
Okay, I'll go through these rather quickly. So based on everything that we found in our investigation, the whole point of this is to produce a report and provide some recommendations for how to change the circumstances in Tanzania, especially with respect to SOSPA. So our first suggestion is the sentencing issue. And we think it's important to allow judges somewhat more discretion in sentencing, although abuse of discretion in sentencing is one of the reasons why SOSPA sentencing guidelines are so rigid, but nonetheless. The proof of penetration requirement has had the de facto effect of requiring medical proof of penetration, which provides almost an insurmountable burden for adult women to prove rape, and that needs to be addressed. Marital rape needs to be criminalized, and whether this is done through an amendment to SOSPA or through some other larger effort to address domestic violence is not, doesn't matter really. And FGM should be prohibited on all women, regardless of their age. And the prohibition on FGM should be more explicit. It shouldn't sort of be tucked under a provision against child abuse. For law enforcement, police need to be better trained and better supported, and this includes general training with respect to gender-based violence, but also specific training for gender units that are at police stations that are designed to deal with these types of crimes. Standardized protocols for police would be immensely helpful, guiding them in how to respond to gender-based violence, along with some enforcement mechanism to make sure that, that these protocols are being followed. Prosecutorial review. Recently there was a law passed in Tanzania that shifted the job of prosecuting crimes from the police to prosecutors that work for the state. However, the problem still exists that the police have an enormous amount of discretion to determine whether to pursue an investigation or whether to forward the report to the police. And so police discretion to pursue investigation or notify the prosecutor should be curtailed. And also, there's paperwork issues. The PF3 requirement also provides burdens on a lot of different levels to women trying to report rape. The PF3 should either be abandoned in favor of another form that's specifically geared to sexual violence. But even if it's not, it should be amended so that doctors have, frankly, there's one of the problems with PF3 is there's not enough room for a doctor to report everything that he might need to report in a case of an alleged case of rape. But irrespective of what form is used, the form should be available to victims at the hospital so that the victim doesn't have to make multiple trips. And that's also a huge barrier to women. As it stands now, they have to go to the police station to get that form, go to the hospital for an examination, go back to the police station to submit the paperwork. And a lot of women just give up before they get through those hoops. There's not much psychological care provided to victims, if any at all. So healthcare facilities should be equipped to provide confidential psychological care to victims. Healthcare facilities also should have protocols for treating victims of rape. And training these protocols and training for these protocols should be available not just to physicians but non-physicians as well. And we were surprised to learn that post-exposure prophylaxis for HIV is not administered in rape cases at the hospitals there. And we weren't actually given much of an explanation at all for why that is, but PEPs are relatively inexpensive and relatively effective at preventing the spread of HIV. Education, public awareness of SOSPA and gender-based violence issues in general needs to be increased. Training at every level of the justice system, police, prosecutors, judges, on the provisions of the law. Public outreach. The government has to educate the public on the pervasiveness and significance of gender-based violence. Education has been a fantastic remedy to the problem of human trafficking, at least that's what we were told. But continuing that to make free education available to school-age children so that they're not susceptible to being lured into trafficking by people claiming to be able to give them an education. And continued and close partnership with NGOs is vital for the success of combating this problem. So those are our recommendations, and actually that's our presentation. Before we adjourn, I want to thank, well, first I want to thank Professor Bond for her guidance and leadership and for setting this all up for us, and Carol Jean Kirby also, who was an asset for Professor Bond in organizing all this. The class, you guys were great. I'm sure the feeling is mutual. And all of you, thank you for coming. Asante Sana, everybody. Thank you. And I guess... I guess we'll have questions, and we didn't really come up with a system for questions, so maybe if you want to, you can direct your question at a specific person if you want, or if you just want to open it up to everybody, that's fine too. So, how about it? Sarah McManus.
I have a question for whoever wants to answer this. You all have mentioned that most victims don't report, or roughly 80%. What do you think makes a victim actually report? Is it the brutality of the rape, or is she in a better circumstance somehow to report it? What do you think actually precipitates the reporting as opposed to not reporting?
What, from some of the discussions we had, some of the cases that are reported usually are incredibly brutal cases, and there are injuries that are involved, and they end up in the hospital in any event. And so there's ample evidence to go forward, but in most cases that type of evidence in that type of situation is what happens.
And I think it's, when it is reported, it's of parents reporting their rapes of their children. That's when you do see it.
And also after unsuccessful settlement attempts between the families of the victim and the rapist, oftentimes you'll have like parents who are unsatisfied with whatever offer go to the police days after or even a week after to actually report that the rape happened. And by that time, it's already too late. But these are also numbers that are also factor into the reporting of these incidents. So, any other questions?
I have a thing in my head that isn't really a question. I'm really fascinated. Is it CEDAW? I'm fascinated by the provision that engages affirmative change in cultural norm as a governmental agenda. And it makes perfect sense to me that that's where change needs to happen. But at the same time, doesn't there have to be will within the culture to make that change? And you're talking about making recommendations. And here we are, a bunch of Americans with unlimited resources and no actual intuitive sense about these cultural norms because we don't live inside them. And I read that provision and I say, well, that sounds like something drafted by a Western nation. And how, in God's name, are we going to, if your goal is to make this change, it seems like the cultural change, assuming that we are correct, that there is some sort of normative correctness about culture and the role of culture and what should be happening. How is your message going to be effective, the work that you're doing going to be effective inside this culture that has, I don't know, I don't have a question, I'm just reacting to this.
It's an interesting point. It's one we actually kind of had a knockdown, drag-out fight with one of the people we're interviewing who works for an international organization. And it is interesting because some of this, we actually had an interview with somebody who was talking, we went in and these were people who lived in a normal town. They lived in an area of Dar es Salaam. And the first thing they said is, they didn't speak English. And through the translator, literally the first thing, unprovoked, they said, we think marital rape should be a crime. And then so we asked, well, why do you think marital rape should be a crime? Because all these human rights lawyers tell us it should be a crime. And then you ask a little bit more, and then they say, no, it shouldn't be. It shouldn't, because it's going to destroy the institution of marriage or whatever. And it was just so interesting because it is a lot of top down. But on that same note, you have this issue of that the law, it works to change the law, and the law has some symbolic value. I mean, it may not, the laws that are passed in the Doma by the parliament aren't really super effective down in the villages.
Well, they're particularly not effective if they're coming from, the UN or the NGOs or these other things, and Tanzania is so under-resourced, and God knows they want whatever resources are going to come, and so if we say, you have to legislate this way, the disconnect is so huge. And it's not that I'm in favor of, FGM, for God's sake. I just am, in terms of effectiveness and how you're going to leverage this systemically, it just seems so challenging.
Well, what the international obligations serve to do is spur action by the government. And then that action, that domestic legal action, has symbolic value. And that helps the whole process. I mean, it's not, that's only one facet of the solution. You know, there's got to be a lot of education at the grassroots level and really people to buy into that. And it's a tough nut to crack, admittedly. But
Is the NGO that y'all are working with local, or is it coming from the outside?
it's local.
And so is the hope that whatever report that you're generating is going to be absorbed by them and translated by them, and I mean that in the metaphorical sense, I think even more than the literal sense, into something that will be coming up from the bottom, essentially,
Yes.
culturally? Is that the
Yes.
hope, at least?
Right.
Frankly, that's where SOSP even came from. It came from NGO, people at the grassroots level recognized it as a problem, and NGOs advocated for change. And they spurred the government the Law Reform Commission to investigate the problem, and the wheels got spinning. It was a long, arduous process, but finally they came out with something. But it started with a problem that was identified at the grassroots level and by those domestic NGOs.
I think most importantly, it's some of these initiatives like, the legislation and the work that we do and other outsiders who come in. It's through invitations from the local people that are actually crying out for help. I mean, you have people in marriages who want to do something about the marital rape they suffer, or like people who have undergone genital mutilation that actually want to prevent their children or anybody else they know from going through the procedure, but in a sense they feel like they lack a voice, and the government will listen to other people, and it's true for a lot of developing countries. By being a signatory to a lot of international treaties, you are assisted financially and given other resources. So sometimes the presidents, the government sort of become signatories to these international treaties in order to just receive whatever perks that are offered by these people. Well, assuming that they've evaluated whether they will qualify for any of the resources that are going to be offered to countries of their caliber. So that's why you have NGOs who cry out for help and want to hold them accountable for whatever they've obligated the country. So it's just sometimes the people are the ones that are crying out for help, and it might look like, you have, outsiders from the perfect world coming in and imposing their judgment, but some of these cultural norms are the reasons why women suffer the injustices that they do. And I come from a culture, and I'm exposed to it even now. I'm not even in the U.S. and the cultures don't stop and the practices don't stop when you even come to the United States, because I know that some of the things that I have to go through as a woman from an African country are just things that my parents expect me to do. They expect me to be the same perfect African girl that would have been raised back home, and it's just impossible, but they still expect me to live under and abide by their cultural rules and norms, even if I'm in this sort of utopian society to them.
I don't know if I'd go all the way utopian now.
Well, it is utopian to me.
Yes.
I want to comment on your recommendation on sentencing to give the judges more discretion. And I was just thinking that in Kenya we fought so hard to give the judges, to remove the discretion from the judges. And that's because maybe the discretion was being abused. Like in one instance, you had a 6-month-old child who was raped, and the court found that the perpetrator was a responsible father and a resourceful person in the community, so they would give you probation, 3 months probation. So there are so many cases like that, and that's why we fought so hard to remove that discretion. Maybe we should rethink that.
Well, if you guys don't mind, I'll start. You notice we couched that with somewhat more discretion. So under the penal code that existed before SOSTA, judges had virtually complete discretion to determine the sentence. And I don't think that we would suggest going back to that. In fact, we haven't sat down as a group and fleshed out exactly what that recommendation is going to look like yet. But the minimum sentence provisions in SOSPA have presented some unintended consequences, though. One of which is, John mentioned this, is it's sort of de facto raised the evidentiary burden that women face, because judges, sensing the gravity of putting somebody away for 30 years or for life, have required rape prosecutions to be virtually perfect before they convict. So there's that problem. There's also the problem of the victim knowing the perpetrator, which is fairly common. And because, as we've said, most of the rape cases that are reported are child rape cases. Most adult women do not report their rape cases. The children that are raped often know the person that raped them. It's either a family member or a neighbor. And often the victim or the family of the victim is reluctant to prosecute when they know that that family member, say it's a family member, when they know that person's possibly going to go to jail for 30 years. And so there's certainly, from that perspective, there would be symbolic significance to allowing some discretion in sentencing. And I don't think, although I'm speaking for the group here, but I don't think once we put our heads together that we would come back and say there should be sort of carte blanche discretion. But maybe the minimum should be lowered, and judges would have discretion to still sentence people to 30 years. But maybe we lower it to 15 to 30 or something like that. And we haven't, like I said, we haven't fleshed that out. But there are, I'll reiterate, there are unintended consequences, we think, to the rigid sentencing guidelines that are there now.
Are there other tribunals that exist in Tanzania other than, I guess, the formal judge, prosecutor, defense attorney? Because it seems like there's a huge problem going on in the country, but certainly not enough courts or lawyers or advocates, whatever, to address all those issues. Did you guys maybe kind of consider how other stakeholders in the community can kind of get involved, or what other, I don't want to say like arbitration type tribunals, or how you would address those, especially in more rural areas where you wouldn't have to travel 6 to 12 hours to get some type of aid, or what other avenues exist?
One sort of area that we met was in they have marriage reconciliation board, and we went to one in the regions are broken down into districts and to wards. So in the city of Dar es Salaam, I think there are like 10 wards or so. And I mean, as it says, marriage is it's only for married persons, but they can go if they have a problem, if there is domestic abuse. They have heard cases of marital rape, but it's not. I'd say there are some problems with that system because the emphasis is strongly on let's reconcile the couple. Let's fix the problem. One case where the woman came and said, my husband is raping me all the time, and they came up with the solution of he was often drunk, so just stop drinking and then have sex, and then you can go drink. And the case didn't come back, so they thought it worked. So it might not allow for a full voice for the woman, but maybe they could be adapted into more of that process.
But I guess, with these types of issues, you're never going to have a perfect situation. 25% of the cases got prosecuted, I think is what you guys mentioned. How many convictions does that result in? I guess, and also my second question was about the sentencing. 30-year minimum is what, and in light of all the corruption that you all mentioned, how, I don't know, that's a little uncomfortable. I'm coming from the public defender standpoint, I think, but what did you all think about that? I thought that was,
I think the practical problems are more, a sentence is what it is. If they deem it to be that severe, then, so be it. But there are some real practical issues with actually prosecuting the crime that result from having such a severe sentence. And I think that's why I think looking at sentencing is important, because of the unintended consequences. But if I would say just something about the arbitration or whatever. One of the problems is that you do have families settling rape cases amongst themselves. They negotiate a settlement, some compensation paid by the family of the perpetrator to the family of the victim. And you know, is that what you want? I mean, I don't know. It's just that's what happens, and that is one of the things that prevents.
Right.
Well, and the other aspect of that situation, the out-of-court settlements that often occur, is the victim's voice is usually not heard in that case. It's usually the victim's family negotiating to get money from the perpetrator's family. There's no vindication for the victim at all, and so they're usually shut out in those situations.
So are you saying that would be better than nothing at all happening? Or, I mean, at least it's something. And I'm not saying that, I guess maybe I'm not speaking properly.
Well, one of the things about the law is, as far as the sentencing, actually there is a provision in there for compensation to the victim, as well as the jail sentence.
Right.
And, you know, what's happened in practice is that someone's sentenced for, you know, and the family is looking, and the victim sometimes too is looking for compensation. And so the person sentenced for 30 years or to life, the family's not going to see that compensation. Given the economic pressures that they're under, would you rather have the perpetrator go to jail for 30 years or get compensation?
Are victims of rape unmarriageable?
They are less marriageable, certainly. They certainly feel.
So there is economic fallout to being a victim, other than just sort of, you know,
yes,
absolutely,
pain and suffering that we would.
Right. And Christina, going back to the sentencing question, if the perpetrator is under 18, they have like a different guideline for what it is. Like the first offense is like lashing, and like the second offense, I think it's
It's up to discretion.
yeah,
Under 17 is up to
monetary,
discretion,
and the third offense, I think they go to jail for minimal. I forgot what the specifics are, but the people of Tanzania are also kind of unsatisfied about the sentencing, because it sort of creates this problem when you have a victim under 10, which is a mandatory life sentence, and a perpetrator who's under 18. Do you give them life, or do you lash them if it's their first offense? So that's something that we actually heard about, and there's this really famous case. There's a musician family actually, and you know the father and his 3 sons, and they used to lure little girls who walked from school every day, and they would have sex with them, and finally they got caught. I mean, we're talking about girls between the ages of, I think, 5 and 8. And finally they got caught, but what happened was one of the sons was actually under 18. So because they were really famous, there was this public outcry about it, but you know, the NGOs and the media, they were really, really vocal about the whole case, and it resulted in a conviction, lifetime conviction. But after that case, it really got people to start thinking about how harsh these sentencing guidelines were. Was it because, you know, you have this celebrity figure who everybody liked in the country, and you know, wants to sort of get them a different sentence because, you know, they come from this well-known family? Or is it because they really feel that, you know, the sentences are really, really harsh? So we don't really know, but that's one of the cases that a lot of people cited. And you know, every time we talk to someone about the sentences, whether they're harsh or not, they just always point to it when they say, yeah, it's really harsh, you know, you have to stay in the state, blah, blah, blah. So they're rethinking it, just like everyone's wondering about the stiffness of the penalties. So.
What percentage of cases that actually make it to court end up in conviction?
Somebody cited
25% of those that actually are prosecuted for convictions. And actually the government can appeal when they lose, but they don't often do that. And one of the problems in with the government appealing is that you have to get the defendant in court again. And when they've been acquitted the first time, they're not going to roll their dice again and show up for the appeal.
How about the prosecutors? Are they all trained lawyers, or is it like the Kenyan scenario where they were not trained lawyers? And one of the recommendations you did was to put all the domestic violence cases to be prosecuted by trained lawyers, which would amount to 1% convictions.
There was a law that was passed a few years ago called the Attorney General's
Discharge
of Duties Act, and that called for legally trained prosecutors employed by the state. It's not yet come to pass that every region has a prosecutor working now. Our understanding, the impression we were given was that implementation is not complete yet. Am I right there?
You know, that's last year.
So you do have prosecutors trained in the law, but there still exists this problem of police officers who, just on the face of the complaint, when the victim comes in, or the alleged victim comes in, might say, "No, I don't believe you." And the case, if that happens, the case ends there. There's no legally trained person that reviews the facts or takes the witness's report and determines whether or not a prosecution should go forward. So in spite of this law, which is a good law, and it's a good change, in spite of this, you still have people that have no legal training at all with virtually absolute discretion as to whether or not to go forward with the case.
I guess there's always an issue when you have Westerners coming in and saying you guys got to do things a certain way. So as far as marital rape, marital rape's wrong, so we don't accept that in our society. And FGM as well, but with marital rape, there's always an element in rape of you're doing something to someone against that person's will. But as far as FGM is concerned, how often do these girls or women see themselves as victims of FGM rather than just people who have undergone FGM and as part of growing up?
Well, general comment about the Westerners' perspective. I know young Ray will want to say something about FGM. But we do accept Professor Belmont's assumption that there is validity to these normative values that we bring to the table. And the other thing I'll say about that is one of the persons we talked with was a board member of one of the NGOs who was extremely excited that we were here doing what we were doing just because we were outsiders and because we were Westerners. The objective perspective that we're able to bring, we saw a great deal of value in that. So that's sort of the counter to the sensitivity that we all felt while we were there, the sensitivity to the fact that we were outsiders who may be perceived to be imposing our values on the locals.
FGM, we didn't really talk to victims except for the one girl who actually escaped. But with FGM, it's something that's so deeply ingrained in these cultural practices that victims don't really receive as a norm. And it's often, young girls who feel like they're going through this rite of passage to be included in as part of their culture and society. So oftentimes they don't realize that it's really a problem what they're going through.
So if you have these young girls, they get the procedure done, and then they grow up, get older, do they often look back and say?
Well, during childbirth, we actually interviewed a doctor, and what they go through. What happens during childbirth is that you have a lot of tearing and a lot of blood loss, right? So that's how they actually realize that the person actually went through the process. But in terms of growing up and realize, unless they remove themselves from that culture by coming to the city life in Dar and being exposed to other things, or marrying or living within communities that don't practice FGM, and they don't really see their cultural practices that are part of their tribal rituals as anything other than just another celebration. So
that's kind of just a second Natalie's point. That's kind of what we saw. Talked to a lot of people, and when people who practice FGM are able to live amongst others who don't, the incidence of FGM goes down. So once there's an awareness that it's not something you have to do, then it goes down, and you have more girls who are trying to get away from it, and that's really kind of the attitude changes.
So is the main goal to educate and say you don't have to do this, or is it just completely outlaw the practice?
I think both.
Because if you want to, I guess what I'm getting at is, in this country, you can get a sex change operation, shot the whole thing off. That's genital butchery. If you want to look at it like that, so to tell like a whole country, you guys can't do this.
Right.
I'm just wondering, is anyone taking the position that maybe we should make sure they do it cleanly, cleaner facilities with better care, better resources. Obviously, they don't have the surgeons that we have in this country. I mean, I'm sure there's some good ones there, but they're few and far between.
Well, there certainly isn't. I mean, what's happening is that some of it is being medicalized. That it's not being done so much by these traditional practitioners. I mean, there are times when you can go to a nurse practitioner, a trained medical person, and they'll do it. But that doesn't eliminate the fact that it's a rights violation, especially for girls. Now, for adult women, we certainly heard some people say, yeah, for girls it's bad, but if an adult wants to do it, they can do it. But there's an underlying stereotype, there's an underlying cultural attitude that makes women subordinate. And because again, the practice stems from this idea that women are not going to be promiscuous. It's about control. So it's again, we're sort of imposing these normative values. But I think in this case you can say that given the origins of it, it's not like a sex change operation where somebody says, gosh, I really want to be, whatever. It's about, I want to submit to somebody else's control. And because they feel these cultural pressures for them to do so. And that to me, I think, I don't want to speak out of turn, but that's certainly a violation of the rights as put up by CEDAW and PVON and other international and legal understandings.
Anyone else?